I should probably warn you that they told me that since I'm the last presenter of the day, they're not going to put me on a clock. But I will endeavor to get you out of here on time or close to it. Are you good? Okay, I think we'll go ahead and get started, and if some more people join us, that would be great. So, good afternoon, everybody. Good afternoon. Excellent. So, thank you for coming to this session. We're going to talk about the Clery Act. My name is Jim Moore, and I am my official title is Senior Advisor for Clery Act Compliance and Campus Safety Operations. That's a mouthful. You can just say the director of the Clery team or whatever it is today. It changes from time to time. But I want to thank you for coming to this session. I think this is a very important topic, and it's one that a lot of folks don't really have enough knowledge about. So, before we get into the detail, I'm going to start with a little disclaimer. The Clery Act applies to all 6,100 schools that are in the Title IV programs, some 14,000 campuses. I think right now it's around 11,000. It goes up and down depending on what minute we take the tally. Those schools range from cosmetology schools with 10 students up to mega state universities. We have schools in this country that have a daytime population well over 100,000. We have schools that have no security at all to schools that have full-time, full-service police departments. Just to give you an idea of the range, excuse me, University of Pennsylvania in Philadelphia has a police department with 118 sworn officers. They have a 12-member plainclothes detective bureau. They have their own SWAT team, a helicopter extraction team, an anti-terrorism division, hostage rescue. That's a college, okay? It's one of the best campus police departments in the entire world. People come from all over the world to see how they run their campus police. And then, of course, we have schools that have no security at all. And those schools all have to comply with the Clery Act, and they all can be compliant in that reality. So we're going to talk in general terms about these requirements, and then if we need to do some refinements along the way, we will. In terms of the agenda, I like to start where other presenters finish. I want to thank you, one, for coming to this conference and this session. I also want to thank you for the work you do. Quite frankly, I don't think people say thank you enough to people in the financial aid business. Clap for yourselves. You deserve it. You know, most of the money that our agency gives away, and it's a lot of money, it's upwards of $150 billion a year, $1.3 trillion in revolving credit and student loan programs. Most of that money gets to the right people at about the right time for the right reasons. So you're doing a pretty darn good job, and quite frankly, so is the department. You won't hear that very often, right? Mostly they only talk about us when we goof up, right? Same with you. Nobody really says thank you to you. I tell people sometimes that when I used to play football many years ago in another life, I played on the offensive line. Nobody cares about the offensive line except when they goof up or they commit a penalty, right? And that's the only time anybody talks about you. So I think you all need to pat yourselves on the back a little bit for the good work you do. What we want to do here is give you some information that you can take back to your schools and maybe participate in making sure that your schools are compliant with the Clery Act. While you're trying to take care of the numerous other requirements, you need to be sure that somebody's taking care of this. It probably shouldn't be you, but it would help if you can make sure that somebody at the school is at the switch on this. We're going to talk about some of the basics around your annual security report, what we mean when we talk about Clery reportable crimes and Clery geography, something called campus security authorities, and safety alerts. We're also going to talk a little bit about the new VAWA requirements and how they intersect with Title IX of the Civil Rights Amendments of 1972. If you don't know what Title IX is, or you don't know what VAWA is, you're in the right place, but if you don't start to figure it out, you have to understand you're a little behind the curve, and we got to get you caught up. A little later, I'll probably ask you to lie to me about what you know about these things. I do that sometimes. And I'm going to start with a quote that I like very much. It's Twain. It ain't what you don't know that gets you into trouble. It's what you know for sure that just ain't necessarily so. You'll get what I mean by that by the end. Very often in compliance work, whatever kind of compliance work, any kind of law enforcement, a lot of the people that are goofing up don't know that they're goofing up, and in fact, they're quite sure that they're not. Somebody has to be checking these things, right? In fact, a lot of schools double down on their mistakes. It happens all the time. You don't believe me? Ask my friend Ms. Morelli here from our Office of General Counsel. She's not taking notes today, don't worry about it. But you can get yourself in a lurch on this stuff 100 different ways. We mostly deal with the people who do a lot of purposeful things. I've done a lot of fraud cases over the years, white collar kind of stuff, all the way through the campus crime situation, drug and alcohol abuse prevention, and 100 other things. Some of that's purposeful behavior. Some of it's just incompetence. And then some of it is something else. And it often starts with a mistake. And I want to try to help you to avoid that. Generally speaking, when we talk about compliance, one of the things that I want you to do in everything you do compliance-oriented is try to develop a system that will detect problems before they become catastrophic. So that brings us to Jean Clery. That's who that is. Killed at Lehigh University in 1986. I told her mother that I would keep putting her face in my presentations until people got the message that this is not about some kind of paper requirement. This is not a twisted test to see if you can comply. This is about campus safety and crime prevention. The components of the Clery Act work together as a system to help provide for safer campuses. If you're just working from the idea it's a bunch of stuff we have to write down on paper that people may or may not ever read, you're missing the point. For some schools, that's what it will amount to. And be thankful that you never have the kind of incidents that take you into a completely different realm on this stuff. For other people, believe me, they understand what I'm talking about here. Again, you need to take care of your institution from the standpoint of preventing catastrophic failure. You are in a very competitive industry, whether you realize it or not. There is a chase for students. That's true for every kind of school. All you have to do is watch the schools compete with each other from where we sit, right? We have a lot of nonprofit institutions that now actively compete with for-profit schools for the same student, and they're competing with the community college and everyone else, right? You want to talk about reputational harm? The kind of stuff that I work with is on the front page above the fold. That's one of the things I often say at conferences that I go to. As you can imagine, most of the conferences that I go to are full of very different kinds of people. Lots of cops and lawyers and risk managers and insurance people and Title IX folks. But you folks understand more than any of those people about how we regulate. And that's why you are in one of the best positions to help your schools at least figure out if your policies and procedures make sense. And you understand where compliance fits in the overall operation of the program, which brings us to quote number 2. If any of you have spent any time in Washington, D.C., you probably were forced to take Metro somewhere. All right? And when it works, it's not a bad little system. But too often it doesn't work, especially if any of you have ever been trapped on the red line at rush hour. For those of you who have, you'll know what that means, and you have my condolences. Recently, Metro hired a new executive director, and he decided that it was time to finally take care of all the kind of mismanagement and abuse and neglect that the system was under for decades. His name is Paul Wiedefeld. He did an incredibly brave thing, and the politicians just about ran him out on a rail for it, one of those rails in his system. He said, I'm going to shut parts of it down because that's the only way to fix it. And they were like, what? This is the worst traffic city in the United States. You can't shut down the metro. No one will get anywhere. He says, well, then it won't get fixed. Right? And so he was in a hearing that I was watching on C-SPAN at like 2 in the morning with 6 other people, because nobody watches C-SPAN anyway. It's just literally, it's a little club, mostly of people with mental problems and who need a hobby. So Wiedefeld's on there, and they're asking him all these technical questions about Federal Transit Administration requirements and checklists and all the stuff he has to do. And he says, that's not how I look at compliance. And he said this, compliance is just something that we do and that happens when we go about the business of keeping people safe. That's the Clery Act. By the way, it's a good bit of your overall regulatory compliance apparatus. 90% of it will be incidental to simply doing the right thing. If it's not, you're probably doing it wrong. And we'll have a few points along the way where I might be able to add to that. Case in point, especially, where are my career school folks? Yeah. There have been a significant increase in the number of career schools cited for violations of the Clery Act, and as Dr. Bob back there knows, a lot of that starts with simply not having an annual security report, or if the school has it, not distributing it in the required way. These are the basics, okay? So one of the requirements is that the school actually has a report. What do we consider a report? Front cover, back cover, all the required content in the middle. In an era where a lot of schools, for a variety of reasons, including technology and cost savings, just make link farms. That's what tech people call it. You just add another computer link to a never-ending list on your website. People would have to click 50 times to get all the content required in the annual security report. That means you don't have a report. Now, what's the solution? How about this? Print it all out and make a PDF of it and post that. Now, to tell you how paranoid and dysfunctional some people in the consultant business have gotten in terms of getting schools afraid about being out of compliance, there was a company running around, and for 5 figures, they would take all your content and turn it into an annual security report, and telling college presidents and others, you're going to get fined if you don't fix this. You know what they did? They basically printed it all out and made a PDF. They made it look a little nicer than that, but that's in essence what they did. You can do that for yourself. You're going to find that in many areas of Title IV. You could do it yourself. Don't allow somebody to bamboozle you into this idea that you need to pay them a fortune because somehow you're not smart enough to figure it out for yourselves. Now, if you need genuine help, there's nothing wrong, and in fact, I would encourage you to find a good consultant, a good lawyer, a good auditor, right? But I'm going to sprinkle a few of these things in this presentation as we go because I think the advice is necessary. Make sure you get value from the people you hire. Make sure you hire people who actually know something about this industry, because there's a whole lot of people trying to make money off of Title IV today who know nothing about it, and they mostly just create problems for people. All right? You can do most of this as an institution yourselves. Now, I would argue that a lot of you as financial aid professionals shouldn't be the one doing it, other than to carry some of this information back and say, good grief, we have to make sure we're doing these things. Are we doing any of this? Does it pass the smell test? If I read the school's policies as a financial aid person, do I say, there's no way that's what we do here? Where'd we lift this? Right? These statistics don't make any sense. These can't be our stats. I know the area. I pay attention to the news. How is it we're reporting zeros all the time? Right? Because there are increasingly people paying attention to that. Up on the Hill, in the media, lawyers looking to bring lawsuits. You want to talk about suits over borrower defense or something? Again, no disrespect to the people who do that work. They're my friends. That's on the business section of the newspaper. You goof this stuff up, or you don't handle a legitimate tragedy the right way, front page above the fold. Okay, so let's start with the basics and just make sure we have a report and that we actively distribute it to our students and employees. What's that mean? You can't just post this on the website. You actually have to send this material to people. Do it by email. It's cheaper, creates an audit trail. One of the things that financial aid people know that you should carry back to all the other people at your school, including those who think they know more than you about the department's requirements, is that tell them they should do what financial aid people do all the time. Do the right thing and document that you've done it. You need to be able to explain to program reviewers or IG agents or your own auditors what was done, right? Because people like me aren't inclined to take your word for it, right? People sometimes ask me what I do for a living. If they don't know, I said I get lied to for a living, right? So we're trust but verify. You want to have some kind of a record of what you've done. Similarly, with your prospective students and employees, you need to actively notify them that this material exists. You don't have to give it to every person who applies for a job or for admissions. You need to make sure that they know that it's available. If you use some kind of portal to apply for jobs or enrollment, make sure that as part of that process, information pops up about the Clery Act. And it can usually say something like, in accordance with the Clery Act, we produce an annual security report. It includes the following. If you'd like a copy of it, click here or call this number and ask Bill for a copy, right? You're already doing stuff like that for EEOC. You're doing it for Americans with Disabilities Act. Some of you have state requirements that you have to disclose that we follow this law or that. Add this one. I'm telling you that it may not seem like something that's going to jump up, but I can tell you that schools that you would have never expected to have some kind of issue around crime to just pop out of nowhere, right? It seems like there's always some mass tragedy that happens right around the time of this conference every year. This year it was Ohio State, just a couple days ago. Now, they just happen to have a world-class police department, and without making any endorsements about anything they did, the early information that we've already started to assess is that they handled that extraordinarily well. A couple years ago, I believe, when we were right here in Atlanta, that was when the Umpqua Community College shooting occurred. And one before that, and before that, and before that, right? Crime knows no boundary. Crime moves. There's no such thing as a safe school, okay? And we have to be prepared for this stuff, and we'll talk a little bit more about just from a standpoint of managing risk, which is something that I think schools need to think more about. Long-term overall risk management, everything from insurance to safety to civil rights, on and on. And now you have to be thinking about program integrity, borrower defense, and the rest of it. Now, back to the nuts and bolts. This is a requirement that actually every school has managed to comply with. Every year, the department conducts a campus crime statistics survey. Your school gets an information packet and has to respond to us with data about crimes that were reported on your campus or in the near campus community. So again, like I say, 100% compliance on this requirement. There's not 100% compliance with almost any requirement. So we're happy to see that. What's the problem? The problem is this. You know how many schools think that that response to the survey is their annual security report? It's not. Program reviewers all over the country go into schools, and among other things, they ask for the annual security report. You know how many of them get a printout from our own system that's a compilation of the statistics that the school reported to us? We wouldn't ask you for that. We already have it. That's what this is. This just happens to be a copy of Harvard's. I picked on them. Nobody ever picks on Harvard. Right? But if we went up to Harvard and they handed us this and said, this is our annual security report, obviously we would say, no, it's not. That's from our computer system, okay? So all of you have a printout somewhere that looks similar to that. We change the format a little bit from time to time, but you get the point. So I would just simply figure out for yourselves, does your school have an annual security report? The one right now would be the 2016 version. It should have crime statistics for 2015, 14, and 13 in it. It should also have a range of policy disclosures in it. If your school doesn't have one, you should get straight to the process of creating it and getting it distributed as fast as you can. You're behind the deadline, but that might not actually cause you any particular problem. But it could, right? Now, I'm going to tell you a little bit about the crimes that schools have to disclose. There's basically 4 categories of them today. What we call overall criminal offenses: hate crimes, arrests and disciplinary referrals, and the so-called VAWA offenses. Now, here's the list of the Clery reportable crimes. This is mostly based on uniform crime reporting system created by the FBI many decades ago. We only require schools to disclose the most serious crimes against persons and property, essentially murder through arson. All right? A lot of state laws, for instance, the law in Pennsylvania requires them to disclose all their crime statistics that they would report to under uniform crime reporting, down to things like gambling and commercial vice. Okay? If you don't know what commercial vice is, right? It's like prostitution and stuff like that, right? We're going to stay out of that. You have enough problems. We stick with the big stuff, murder through arson. Now, what's the difficulty in sticking with the big stuff? All of a sudden, it matters how you classify things. Think about this. We count, for instance, robbery. All right? Robbery analytically is larceny plus assault, right? Because you steal somebody's stuff from their person or presence, that's larceny plus assault. Burglary is the breaking and entering of the dwelling house or office or person that doesn't belong to you for the purpose of depriving them of their property, right? As you might imagine, there are schools that have robberies and burglaries that they classify as larcenies, lower level theft offenses. If you do that, those crimes are not going to end up in your statistics. Right? If we made schools disclose everything, including every kind of larceny offense, and there are tons of them in the law, well, then at least even if you misclassified the crime would be in the total number. You'd have a classification problem, but not an overall statistical issue. But because of the way we do it, there's whole categories of crimes at some schools that never get disclosed. That's what's going to get you into trouble. All right? Murder through arson, essentially. For the arrests and disciplinary referrals, we deal with drug, liquor, and weapons offenses. Now, that might sound hard, but pragmatically it's not. Okay, we're talking about arrests, which means you violated the criminal code. Now, if you're in a state that has truly decriminalized marijuana, for example, it might not be a crime to smoke pot anymore. It might be some kind of civil violation or no kind of violation at all. But most places, it's still technically illegal to smoke marijuana, and there's all kinds of legal issues that affect how you classify those things. Liquor can actually be a little bit more tough, and here's why. If somebody is arrested for underage drinking, that's pretty clear. But you might cite people for violation of your conduct code for things that aren't law violations. Case in point. If we're at a school that's a dry campus, there are schools that live under the delusion that they're dry campuses. Dry campus. You don't know how many places I go to, they say, oh, well, you don't need to look at the liquor. This is a dry campus, Mr. Moore. Okay. So, dry campus, some kid, 22 years old, found drinking in the dorm. He's not breaking any law. So if he gets cited under the conduct code, that is not a disciplinary referral that we have to count, right? A lot of schools have rules that say things like in our dormitories, no matter what your age is, you can't drink in the presence of a minor. Because they're like, that's just tempting fate, right? So let a bunch of 19-year-olds hang out with the 22-year-olds who can legally drink. But is that a violation of the law for an adult to drink in the company of a minor? No. If it was, there are a lot of parents in this country. We'd have like child and youth folks showing up every day, right? So you got to keep the analysis clean. We're looking for arrests or disciplinary referrals for actual violations of the law. In a lot of states, there basically are no weapons offenses anymore. In a lot of states, you can basically show up at church with a bazooka and you're not going to violate the law. It's very hard, very few weapons offenses anymore in most states, except for a few that have tougher standards. Massachusetts, California, Illinois, right? But most states, very few weapons offenses to violate. Okay, you have to have like a knife that's 12 inches long in some states to violate the law, regardless of what your conduct code is. So keep those things separate. Hate crimes. What I want to tell you about hate crimes has less to do with these definitions and more about campus climate and dynamics. If you start to see an uptick in hate crimes on your campuses, and believe it or not, more financial aid people are finding themselves getting this information. You know how it comes in? It comes in through SAP appeals. That's the same with sexual assault information. The kid comes in and says, I need a SAP appeal. Why? I was the victim of a sexual assault and I haven't been able to cope. You need to help me. Or I'm the victim of domestic violence and I had to move out, ergo I don't have child care and I don't have access to the car anymore, so I didn't go to school, so I failed, so I need you to help me. Right? You can't escape this stuff. And the same is true with the hate crimes. I have had more and more cases where the first indication of a hate crime problem is in a bunch of financial aid appeals. The actual number of people committing hate crimes in the United States, well, up until the last couple of months, has been down. But the number of offenses on college campuses goes up. It's a small group of people doing it, but basically what it comes down to is that colleges and universities have, as you certainly know, embraced diversity of various kinds and inclusion, and there's a small group of people who really don't like it. You start to have these problems on your campus and you don't do something about it, you will have a full-blown problem in a very short period of time. Schools need to get on top of these things for your own well-being as an institution, let alone the fact that it creates all kinds of exposure under the civil rights laws and potentially under Clery. So a word to wise should be sufficient. But if anybody commits one of those criminal offenses, one of those hate crime offenses listed there, those additional categories of simple assault, intimidation, larceny, or vandalism, or any of those VAWA offenses, and they do so because they've targeted a person for their actual or perceived membership in a protected group, what the law usually refers to as a suspect classification, such as race or gender, or under the expanded rules, gender identity, perceived gender, national origin, and so on. That's a hate crime. Now, just to help you keep this straight, just because you have two students, one of whom happens to be black and one of whom happens to be white, and one commits an aggravated assault against the other, that doesn't make it a hate crime. I see schools get this wrong in both directions, usually in undercounting, but some schools overcount, right? It has to be that you attack the person because of their membership in the group. So if you have two people who are best friends and happen to be roommates who are of different races, something happens, they get into a fight over a girl or who ate whose food, that does not constitute a hate crime. Okay, so we need to keep these things straight. One of the reasons, again, that I go into this level of detail at this conference is because you will find yourself in meetings and discussions with other campus officials, and you might hear some of these issues discussed. And at least if we put some of this information out here, and we have found that it works at this conference, again, financial aid people continue to bail out their schools on other issues, you might be able to set somebody straight before they create a problem for the whole institution. Now, at the talks that I give at a conference of like campus police officers, we'll talk about this next point for like half a day because it's that important to what they do. We're going to spend 30 seconds on it. You'll get the point. Under the Clery Act, an incident of crime is considered to be reported anytime that incident is brought to the attention of campus police or campus safety officials or another so-called campus security authority, and I'll tell you what that is in a little bit. It's reported. There's no such thing as unreporting a crime once it's reported. There is such a thing as unfounding a crime, which means based on the available evidence, we have determined that the report itself was false or baseless. It was a prank or something like that. That's a very small category of cases. If a person comes in, as in a case that happened not long ago. Young lady reports to the police department at her school. 3 o'clock in the morning, freezing cold out. Her clothes are ripped, she's bleeding from the face, and she told the police, "I was sexually assaulted." They somehow divined from that they didn't have to report that crime, and when we asked, here's what they said. They said, "Well, Mr. Moore, you have to understand this school has a protocol. She was required to come in the next day and give us another statement with additional information and provide her clothes for forensic testing and give us a list of witnesses and do about 5 other things." And of course we said, "We don't care about any of that. I don't care what your procedure is. Here's what the law requires. Maybe you need to change your procedure. And oh, by the way, it's barbaric." All right? Here's where financial aid people get this. I've explained it this way to people at financial aid settings. They're like, "Yeah, that makes sense." What's our rule and how you figure out when a kid drops out of school for Title IV purposes? When they come into the financial aid office and tell you, "I quit," right? Now, your school may have a policy where they give you some form, right? And it says you have to get 10 signatures on this form before you're considered withdrawn. And oh, by the way, half of the people on the list are only here on alternate Tuesdays between noon and 1. That's why the department made the rule the way they did. Because we're not going to wait around for the kid to fill out your form. If we did, no one would ever withdraw. And that's how we do it for crime reporting. Kid comes in and says, "I was a victim of a crime," that's reported. It's the school's job to document it. That kid could decide they don't want to cooperate with your investigation. And a lot of schools, the kids don't want to because they don't trust the process. But they feel as though they have to at least file an initial report. So you could very easily hear some of that discussion around campus. And if you hear that from people who have responsibilities for the Clery Act, I would speak up and say, you might want to look into that because I don't think that's the standard. Now, much of this information I have included here just as reference material so that somebody at your school could look at it later if they want to. What you need to know is that in June of this year, we put out a new handbook on how to comply with the Clery Act. The original version was in 2005. We had a revision in 2011, and now this is the 2016 version. It is the best guidance that the department has ever put out on the Clery Act. What we have done here is include, after certain of these topics, parentheses with numbers in them, like that one that says 3.7 there, 3-7. That means Chapter 3, page 7 of the new handbook. So somebody wouldn't actually have to go through all, whatever it is, 250 pages of the handbook to find what they want. If they had this presentation in front of them, they could go right to the topic that matters to them and cut through some of the chaff to get to the wheat. Okay? So you'll see that throughout. I'm not going to go into detail in this audience on every one of these topics. I just want you to know that this is the kind of information that we have issued guidance on. In the Clery area, we don't issue all that many dear colleague letters and that sort of thing. We're going to start to do more with it. Most of it comes out in the handbook. Somebody at your school has to know that this handbook exists. Otherwise, they'll be hopelessly behind. And there are a lot of schools where I can tell you from the casework we've done, nobody at the school even knew there was a campus safety handbook, and certainly no one's ever looked at it. But to give you an idea of the kinds of things that are covered in it, we explain what aggravated assaults are under the Clery Act. Because unless you've been through criminology class or, God forbid, law school, you probably have never had to deal with the vagaries of how crimes are classified. They don't even cover that in law school, really. Aggravated assault is a wide range of crimes. If somebody has a weapon, I point a gun at you, and you're in fear that I'm actually going to shoot you, that's an aggravated assault even if I never pull the trigger. Because I put you in fear of death or great bodily harm. Slide down the scale to attacks with hands and feet, you actually have to hurt the person for it to be an aggravated assault. So not every time a person gets a black eye or a bruise is it an aggravated assault. In fact, usually it's not. But if you beat somebody with your hands and fists or feet to be unconscious or you break their jaw, they require serious medical attention, that's going to be an aggravated assault. Now, here's what confuses schools, including schools' general counsels. They say, well, the prosecutor only charged him with simple assault or with battery. If you start down that path, you'll forever be messed up on this stuff. It has nothing to do with what a person is ultimately charged with. It has to do with whether or not the incident, as reported, fits into the definition of what is an aggravated assault under the Uniform Crime Reporting System of the FBI and the Clery Act, because we tend to mirror each other, okay? Burglaries are completely misunderstood in the campus context. So most burglaries in the campus context do not result from actual breakings and enterings the way you would see them portrayed on television. These kids don't lock their rooms no matter how many times you tell them, right? They leave the door wide open. Well, you can break a wide open door under the law. So if I'm walking down the hallway in the dormitory and I look into Timmy's room and I see that he has all of his cash on the side table, and I reach my arm in there and take his cash off of the table, that's burglary. You can break a wide open door. The minute I stick my arm past that threshold and take his stuff, all of the requirements are met. Breaking, entering, dwelling of another for the purpose of depriving him of his ownership in his property, right? Again, you'll get schools that will run it around you 10 different ways. It's not. People had legal entry, right? Well, you can actually have legal access to a place and convert it to illegal access. That happens all the time in the law. If you essentially are a licensee, you have a reason to come into somebody's dorm room to fix the heater or something like that. Okay, you can do that. You hang around in there after the fact and start stealing people's stuff. Now you're a trespasser and you can become a burglar, right? Somebody at your school has to get that. I'm not saying it should be you. Somebody has to understand it. At too many schools, nobody does. Arson is another one. I can tell you at the negotiations on the rules back in 2010 when we added the fire safety requirements, they argued for like 2 days over what a fire is. That's what happens when you fill a room full of policy people and lawyers and cops, right? They'll fight for 2 days about what a fire is. Here's what a fire is. If something's burning somewhere where it's not supposed to be, that's a fire. If somebody sets that fire on purpose, that's arson. It's pretty simple. I go to schools all the time and, somebody will come in and they'll say, well, Mr. Moore, apparently you don't know. In this state, a fire is not an arson unless the state fire marshal determines that it is. And I'll say, no, you don't understand. The federal law doesn't require such a determination. They even pull stuff on us all the time. They'll say, well, nobody actually investigated it, so it can't be an arson. Of course, that's ridiculous. So in colleges, one of the most common things in dormitories is people love to set the trash cans on fire. The other thing is, those little marker boards on the dorm room doors? Kids love to set those on fire. I don't know why. Just for the lack of anything else to do. That's arson. Okay? But there are schools that fight with us about that all the time. Hierarchy rule, here's all you have to know in case you ever somehow get pulled into this. Think of Jean Clery herself. The day Jeannie was killed, that crime started as a burglary. As part of the same transaction or occurrence of crime, she was sexually assaulted and ultimately murdered. Under Uniform Crime Reporting Standards and Clery standards, you would typically only count, historically, the murder. You count the highest crime. Now, under our revisions to the rules, if you have a sexual assault that is also a murder case, you count both. That may sound like a big deal pragmatically. It's not, thank God. We still have fairly few murders on college campuses, even fewer that start as sexual assaults. But it was an attempt to give context about those kinds of crimes because they do occur. So we're looking to the highest crime in a transaction or occurrence. Now, about arrests and disciplinary referrals, you heard me say a little bit ago that there's these 4 distinct categories of crime, and one of them are these alcohol, drug, and weapons offenses. Okay? It used to be thought, wrongly, by the people who used to do Clery in the department years ago, that you had all those serious crimes against persons and property, and then part of that same hierarchy list was alcohol, drugs, and weapons. That was never the intent of the law. Those things are totally separate. So you could have an incident of crime that occurs at your campus that is scored under the murder to arson section. You could also have a drug, alcohol, or weapons offense that occurred as that same part of that same overall incident. It could constitute a hate crime at the same time, and it might be a VAWA offense. Think about it. It's not that hard to think of an aggravated assault that somebody commits that's also a weapons offense, that's a hate crime, that might also be, for instance, domestic abuse, right? One in each quadrant. We talked a lot about this alcohol and drug stuff, but the only other thing I wanted to point out to you is again, if you're in a state that has truly decriminalized small amounts of marijuana, you might not have to count those offenses anymore. Just make sure that your state really has decriminalized. Most states have not. Very few have. Of course, we know about Washington and Colorado. There's a few other states that have turned it into essentially a civil violation. And of course, we have maybe up to 30 states now that have medical marijuana. One quick thing about medical marijuana, this is really a point for the Drug-Free Schools and Communities Act. Please don't take possession of your students' pot. Schools keep doing this. Okay, so a lot of schools, for good reasons, have policies about, you know, if you're on Adderall or OxyContin or one of these very addictive prescription medications, the school will say, look, don't leave that stuff in your dorm room. Give it to us. We'll make sure that you get your doses on the right schedule, but we don't want people stealing it from you. We don't want you tempted to sell it for $30 a pill, whatever. So some schools thought, well, this is a medical marijuana state. How about we hold your grass for you? That makes you a drug dealer. Under federal law, Federal Controlled Substances Act says that marijuana to this day is a Schedule I narcotic. That means by definition it is addictive and dangerous and has no medicinal value. That's what the federal government says. That, by the way, is why in no state does a doctor prescribe marijuana for you. That could get them in trouble at the federal level. What do they say? They say, my patient may be able to benefit from the medicinal value of THC, which is the active chemical in marijuana, right? That is all purposefully done. It's why there's all kinds of major robberies and burglaries happening out in Washington, Colorado at the big drug pot stores. You know why? Because the people who own them are afraid to put their money in a federal bank. Because anytime they want to, the DEA could change its policies and say, we're going to go seize all that cash as illegal drug proceeds. They're not going to, at least that's what they've said, unless they think you're part of a criminal ring or something. So you know what people are doing? They rent like one of these storage facilities and put millions of dollars in there because they don't know what else to do with it. They do all their business in cash. But there are schools that are taking possession of pot, thinking they're helping. You're actually violating federal law when you do that. Encourage your school not to go down that path. Hate crime information, again, this is the section where I included these slides just as background information for you to possibly pass on to somebody at your school with the appropriate references to the new handbook. Requesting statistics from local law enforcement. This is important for y'all. Under the Clery Act, especially for those of you who don't have your own police or security operation, all the crime statistics you disclose, you're going to get from local law enforcement. Okay? Well, that means that you need to request them from local law enforcement. Now, here's how I want you to do it. If you do it this way, you'll never end up with a violation. I want you to send a letter, or somebody at your school to send a letter in like September, April of the year, and say, dear beloved Chief of Police, we have to comply with this Clery Act, and that means we need crime statistics in the following categories for the following addresses and the streets and sidewalks that are accessible from or adjacent to our property. Most people give them a little circle. and say, give us what's in the circle, right? Now, if you don't get a response to that letter, I want you to send the letter again, say in June or July. And I'm going to keep pinging you, Chief, until you give me some information, all right? Now, let's say you don't get any information. What you're going to do is if you have a program review, or your auditor comes in and says, I want to see where you asked for the crime statistics, you're going to say, I sent these 2 letters, we didn't get a response. That's going to be your documented good faith effort. That's what the law says you have to do, have a documented good faith effort. Never said what it was, I just told you what it was, right? If you do that, you'll be held harmless on that requirement so long as we don't find out in our investigation that you kind of set it up with the chief that he wasn't going to respond. That happened in one of our cases. It was actually email traffic. It said, Chief, we're going to send you this letter. Please don't respond to it. They won't like it if we actually publish all these crime statistics. Okay, don't do that. But otherwise, you'll be fine. You'll be fine. Again, I just want to hit for a second on this unfounded issue because it's confusing to people. Remember I said that once a crime is reported to you, you have to disclose it unless it's unfounded by law enforcement. That's a law enforcement term. Here's what it means. It means that the evidence, whatever evidence is available, indicates that the reported incident is false or baseless. It doesn't mean that the school didn't have or the police didn't have enough information to prosecute, for example. It means that the evidence actually suggests that it was a false report. So here's an example that I use with people all the time. Let's say that you have a report comes into the school's security department that says there's a giant fight happening on the quad. There's 100 kids out there fighting. There's beer cans and teeth everywhere, right? The police respond 2 minutes later, and all they find are 2 kids running off into the woods laughing, right? Because, yeah, we pulled one off on the cops, wasting their time, right? Okay, so that's a false report. There's no teeth, there's no blood, there's no beer cans, just 2 idiots who decided to put in a call to the cops, all right? Now, if you look at the bottom of this slide, you get back to this issue that I was talking about contextually just a little bit ago. You can't unfound a case just because a victim or witness refuses to cooperate. You can't do it just because you didn't bother to conduct an investigation. That keeps happening under the Title IX provisions around civil rights requirements. Schools will say, well, we just didn't do an investigation, therefore we don't know if the allegation was legitimate. Think about how ridiculous that sounds. That's why schools have to have a Title IX coordinator. That's where you start to see the bridge between Clery and Title IX, right? Or the prosecutor just says, I don't want the case. And so the school says, well, then we're unfounding it. No. You know, most crimes that are committed in this country are never prosecuted. Very few ever go to court. Depending on what state you're in or what prosecutorial district within a state, you know, it might be 5% of the criminal cases ever go near a courtroom. 3 to 5% is common. All the rest will be plea bargained or just let go. Because the prosecutor, everybody in the prosecutor's office has 200 cases. That doesn't mean the incident didn't occur. That's why the whole crime reporting system in this country is based on reports. So when you hear those statistics on the news, there's a very popular alarm company that says there's a robbery in the United States every 6 minutes, there's a burglary every 22 seconds. That all comes from the data that's collected through uniform crime reporting. If you went by how many were actually prosecuted, the country would look really safe, right? So you got to make sure that we're looking at this the right way. In terms of Clery geography, these are the spaces that you own or control and that have to be counted for Clery reporting, okay? Might sound complicated for most of you, it won't be. A lot of your campuses have very defined geography, right? Especially like with a lot of career schools, you're in the office park or you're in the mall or you're wherever you are, right? But some schools get very dispersed these days, right? Because there's no place to build a new building, so you build it a mile away, all right? But basically what we're looking here at is, what does the school owner control? Ownership's easy, control can be tough. Generally, that's going to be what you hold by lease. But it could be space that's gifted to you, say, by a wealthy alumni. We had that at a school recently. A kind of an eccentric old guy wrote on a piece of paper that his school got to use his mansion as the geology department for the next 50 years. He charges them like $1 a year or something and makes them pay the insurance. Now, in some people's view, they'd say, well, that's not part of the campus. It's down the street and around the corner. But think about it. What does that definition say? Owned or controlled. Same reasonably contiguous geographical area. If you ever have to figure out what that is, think about a mile. That's used in direct support of or a manner related to the institution's educational purpose. Do you think the geology department has an educational role? Probably, right? Now look at that second definition. This all came out of a case that we did back in 1998 when we had to expand the idea of campus geography because schools were changing, right? Think about it, your school. What does this say? Building or property that is owned by the institution but is controlled by another person. Think about if your school has a food court. It's probably not involving food service by school employees. It's Subway, it's Taco Bell, it's whoever. How about your bookstore? Increasingly, bookstores in this country are run by Barnes & Noble or Amazon or somebody, but your campus bookstore, that's part of your geography, okay? Non-campus building or property, stupid name for something that's counted as part of the school's geography, and you start it with the term non-campus, but try to get past that. Any building or property owned or controlled by a student organization that is officially recognized by the institution. Who's that going to be? Those are your fraternities and sororities who actually own or lease their own house, okay? If they own or lease a house, you got to count what happens there. Schools also have to count the immediately accessible and adjacent public property. Now, that might sound complicated. For most schools, it won't be. Occasionally, you get some school that backs up to a national park or something. We have schools that back up to Central Park in New York, and they're like, well, you're not really going to make us count all of Central Park, are you? No. Immediately accessible or adjacent. But we work with those schools separately and figure out where we're going to draw the line. For most of you, that's going to be the sidewalks and streets around your campus. Occasionally, you get a school that backs up to like a subway station. That's not good. Okay? But here's what it isn't. Okay? We have a large number of career schools in their crime reporting the last couple of years. They have almost no crime on their actual campus, but they're reporting these huge numbers of crimes on public property. And we said, this can't be. And we found out that it wasn't, but they were trying to do the right thing. So here's what was happening. You have a school in an office park, right? They're surrounded by other businesses. There is no public property. Everything's owned by somebody else, right? But what was happening is let's say that you had a school in an office park that was surrounded by businesses that have a lot of contact with the public, and they were having robberies there or burglaries. They were disclosing those crimes as happening on the public property around their school. Well, we said to them, but think about it, it's not public, it's specifically owned or controlled by someone else, right? This is public lands, all right? Now, I quickly want to go to this idea of campus security authorities. So if you want to know what you have to count under the Clery Act for crimes, you have to have the right kind of crime, or if you want to think of it that way, the wrong kind, right? One of those 4 quadrants. Has to be on the right geography, what we now call Clery geography. And it has to be reported to one of these people, who are called campus security authorities. Campus security authority, a couple categories of them are really easy to understand. If you have a police department or a non-law enforcement campus security office, right? And we differentiate between those two things just to be clear. Again, like I told you, some schools have deputized, commissioned law enforcement officers. Other schools have non-sworn security officers, okay? But either way, that's a public safety presence. There are also people who are involved in public safety activities that are specifically not part of one of those operations. Think about at your school, if you have dorms, you might have desk receptionists who sit in there at night and check IDs to try to make sure that some part of your visitation policy is actually adhered to, right? Or you have people who control access to like a parking garage, right? That's physical security access, right? If that person has a crime reported to them, they now have to make sure that those things are included in the school statistics. Here's the category that is the overarching one that gets schools into trouble. Any official of an institution with significant responsibilities for student and campus activities. Every school has to have at least one. So for some career schools, the problem is they never thought to designate anybody. A lot of schools have, that'll be, say, the director of the school, or maybe the director of education, or of student affairs, if they have a student affairs operation. At some schools, this is literally thousands of people. Because who's covered by that? That's everybody in your student conduct operation, athletics, residence life, Greek affairs. Think about it. It could be a lot of people. So in the recently concluded Penn State case, and by the way, anytime I mention a school in this presentation, it is because they are settled, closed cases. It's not to pick on the school, it's because it gives you a place to look if you want to know where we've come down on various rulings. In the Penn State case, they thought for years that they had as few as maybe 300 CSAs. As of the date we issued our report, November 3rd, 2016, they have 4,024. Now think about if they thought they had 300 and they have over 4,000, what that was doing to their crime statistics over the years, right? That could happen at your school, and then you're like 5 minutes away from having somebody like me show up, okay? Now, out of all those people that are denominated as campus security authorities, there's a group that we carve out and say they don't have to report, and those people are people with counseling duties. Actual counseling duties of the pastoral or professional nature. Now, to give you an idea, we go to schools where everybody's a priest or a rabbi. That happens. The football coach is a priest, right? The dean of students is a rabbi. They don't get out of this when they're in those roles. We have schools in this country that teach social work or psychology or counseling where literally everybody who's employed there has counseling credentials, but they're not acting as a counselor. They're acting as the volleyball coach or the director of housing. So it's not just that individual person's credentials, it's the job they do. And unless they are offering pastoral or professional counseling as their campus job, if they have significant responsibilities for student campus activities, they are in the circle of CSAs. You're going to find that virtually every CSA is also a responsible employee under Title IX of the civil rights requirements. It doesn't work the other way. At a lot of schools, they'll actually have more responsible employees because you probably have heard faculty members count under Title IX. Faculty members don't count under the Clery Act. We thought that would be a step too far. Okay? So hopefully you get the idea. One of the things that we put in the handbook is a list of positions that typically will be CSAs. Somebody at your school will probably want to go through Chapter 4, Page 3 of the handbook and say, okay, let's figure out who is and who isn't a CSA. And you can use some of these examples to get you there. But there you see, Coordinator of Greek Affairs, Title IX, on and on, a victim's advocate if you have them. A lot of schools now have advocates of various kinds. Well, advocates by the nature of their work are specifically not confidential. They're going out trying to get services and accommodations for people. They really can't do that without telling people about what they know. Okay? 2 kinds of safety alerts. Timely warnings and emergency notifications. A timely warning has to go out when a clearly reportable crime occurs that may pose an ongoing threat to the students or your employees or the greater campus community. Emergency notification actually covers a much wider array of dangerous conditions, like a credible bomb threat, some kind of serious weather event. An outbreak of meningitis would do it. Somebody at your school should actually be thinking about what you would do if all of a sudden you had 1,000 sick kids who you can't just send home. You can't tell you how many schools have never thought of that. I had a university that ended up with 1,700 sick kids with a very serious communicable illness. And up until the time that it started, they had never thought about what they were going to do with those kids. That's a mess. This is a very remote school. They couldn't just send them all home. Some of them lived in foreign countries. Okay? But as part of an overall emergency management plan, people should be thinking about how you would deal with something like that. Okay? Again, there are different ways to issue these warnings. A lot of schools increasingly do it by text message. All right, but you can use email, reverse phone calling, closed circuit TV, radio, sirens. There's 100 ways to do it. But you have to make sure that what you have employed will work for your school. By the way, if you tell the department that the way we comply with all of this is by text message, it's probably going to be a problem, because the next thing we're going to ask is, you make everybody participate? You're probably going to tell me no. We let them opt in. Well, if you let them opt in, how are you going to reach all the people that aren't in, right? Or who have opted out? You got to have something else. Email, sirens, something. At small schools, I have one little for-profit school. They basically took over an old elementary school. They still have the intercom in the school. That's how they issue their warnings. That's fine. There's lots of right ways to do this. And for the most part, it can be done simply and without extra expense. We have schools that, because of the risks they face, one school in Florida that has a very extravagant system for making these things work because of certain threats that they're worried about, everything from hurricanes and tornadoes to various kinds of criminal activity that happen in their community. 37 redundancies built into their timely warning and emergency notification system that takes into account virtually every kind of emergency they could have, right down to if the person who was supposed to push the button is shot and killed. There's a contingency for that. All right. All we need you to do is have something that fits for your school. If your school has a campus police or security presence, you're also going to have to maintain a daily crime log. If you have housing, you have to comply with the fire safety requirements. Crime log, we don't have to go into it in detail, just know that you would have to have one. Here's where schools get themselves in trouble with the log. You not only have to have the log, you have to make it available to anybody who wants to see it. And schools will say to people who come in and want to look, whether they're from the media or the campus press or just some concerned parent, why do you want to see that? You can't see that without an appointment. Then they'll complain to us about it, believe me. Okay? So you want to make sure that whoever is in charge of that log knows that it has to be free and open to the public. What I would encourage you to do, I've had financial aid folks do this before and bail their schools out before they have a problem. If you have some work-study kid, after you get all of your award letters out or whatever, there's a little lull in the action, send them over to the police department and say they want to look at the log and see what they're told. I've actually had schools take me up on that, and they call me and they're like, they told him he wasn't allowed to see it. I'm like, yeah, right, okay. Tell him that if they don't let everybody see it from now on, you're going to call the department, and that tends to fix the problem. Okay. Missing student notification. This is a fairly new requirement under the law. Most of your students will not ask to ever file an emergency contact. For the very small number of kids who do, it could be part of saving their lives. This provision has actually saved lives because it's made schools blow the whistle before the laws do. You know, in a lot of communities, the police won't even take a missing persons report for 48 hours. Okay? And this system will basically require schools to take some action if people go missing. It also allows people who are afraid for some reason to register an emergency contact so that that person can let folks know Susie didn't come home, right? What you can't do is just assume that people want their emergency contact to be whoever they told you their emergency contact for everything else was when they registered. You know why? Statistically, who do people list as their emergency contact at the time of enrollment? A parent, right? Statistically speaking, from a threat assessment standpoint, you know the person most likely to want to do the student harm? They're second on the list after an intimate partner. I had a case where a guy was stopped doing 90 miles an hour. He had called his daughter and told her that he was going to kill her. He was going to kill her because she had taken up in a relationship with somebody of a different race and he didn't like it. He was caught by the police going 90 miles an hour with a gun and a knife in the car. And he was on his way to kill his daughter. And was dumb enough to actually say on tape in an interrogation room that of all the things he was angry about, including being arrested, it was that he did not get to slit her throat. That's a real story. We had a parent who threatened to kill their kid because the kid changed majors. And the parent said something on the order of, I pay for business, I don't pay for art. You know, I mean, this is the kind of crazy stuff that happens. All right? If you had to sit through some of the stuff that I've been involved in, you just wouldn't believe, right? You wouldn't want to believe. But if a kid wants to register one of these confidential contacts, let them do it. You don't need an expensive database to do it. You keep it on a piece of paper somewhere, probably in the police or security office or in the custody of some other trusted official. Fire safety, we don't have to go through in detail because guess what? It parodies the crime requirement. Guess what you have to do? You have to have an annual fire safety report. You have to submit fire statistics to Ed, and you have to have a fire log. Does that sound like anything you've already heard? If you put campus safety where it says fire, you'd already have it covered, right? By the way, with the log, you can have one log that includes all the information about crimes and fires. There are people who complain about the fire requirements. I can tell you they too have saved people's lives. Remember that most of these requirements were a half measure, governmentally speaking, from a public policy perspective, between doing nothing, which was unacceptable, and direct federal oversight of, say, what smoke detectors you use, which would have been a step too far. All these rules do is say you have to be transparent about what you do. You can publish. We don't have any fire detection equipment, and we don't have fire suppression equipment. We don't think it's that important. Or we think it kind of makes the atmosphere ugly, right? So we don't want that. Or we don't hardwire our smoke detectors so the kids can cut the wires anytime they want so they can smoke their medical marijuana, right? I have had cases where parents have called us or emailed us and thanked us for this requirement and said, I moved my kid out of the dorm they wanted to stick him in because of what I found out in that fire report, right? But once you have this stuff written, for the most part, it won't change that often, right? You're not building a new dorm every day, right? So Violence Against Women Act. We're just going to do a couple minutes on VAWA. Here's what you need to know about it. The Clery Act was amended in 2013 by something called Section 304. VAWA is a huge law that impacts numerous federal agencies on everything from employment rights for women, among others, disability concerns over at HHS. A lot of it's in the Department of Justice. Section 304 amended the Clery Act to require schools to do more in the area of sexual assault prevention and response. Also, to finally start to address issues of domestic and dating violence and stalking. Stalking is a real problem on college campuses, especially cyber stalking. So you don't need to get in anybody's face anymore to stalk them. You can use apps. There's apps you can buy to do that. By the way, you can commit hate crimes by apps. There was a guy who created an app that you could send to somebody. It creates these little messages that look like smiley faces until you click on them and it's like a lynching or like a Klan mask. Stuff like that. People use technology to do awful things. Well, you can also stalk people remotely, right? And schools have to do more now to intervene on those incidents. The government simply is not going to countenance it anymore, all right? We got to do better than we have done. So we have to disclose incidents through the statistical information in the annual security report. More importantly, we have to have policies and procedures to start to address these things. Ongoing awareness campaigns, training around primary prevention and risk reduction. Primary prevention is kind of a long-term strategy to make sexual assault and other intimate partner crimes less likely to occur. Risk reduction is the idea of doing something to keep somebody from becoming a victim right now. So to give you a quick idea about how some of this might fit in, there was a prominent school that had a fraternity that was actually requiring their pledges to go to a class about how to rape people. All right? Now, when the school found out about that, we expected them to intervene and put a stop to that particular course. We've also worked with schools to do things like this. There are a lot of schools, especially very prestigious schools, because they're the kind of schools that you would go away to by yourself. You're not going to have 10 of your friends with you. 10 of you aren't getting in, right? So you find yourself in a new community. You don't have a lot of friends yet, and all of a sudden you, as an 18-year-old girl, get a text message invitation to a party anonymously that says a van will pick you up on the corner at 7, wear your finest. Now, you don't know where you're going. You don't know who invited you. You're not allowed to bring anyone with you. But are you going to go? Yes. Of course you are, right? And there's probably some of us in this audience who did some awfully stupid things in college, in our youth, that we wouldn't do today, right? But that stuff happens all the time. Now, what we're saying is, by the way, in the case of that particular fraternity and several others, you know what they've done? Not only does the van have to go up a very long driveway at the house, you fill the driveway with sharp rocks. You know why? Because it's hard to run in heels on rocks. And if you take your shoes off, you're going to have to run on the sharp rocks. You can't get away. That's on purpose. That's how rape mentality works. That makes perfect sense to me as somebody who studies criminology, right? But to a normal person, that would seem horrible. But sometimes for these things to work, for you to have an understanding of them, somebody at your school has to think like a criminal. That's what works, right? And part of this is all to get schools to be starting to think about how the bad guy acts, right? And to try to intervene before something bad happens. Now, again, we have put all of the references to the new handbook in here. We're not going to go through this in detail, but somebody needs to be looking at this stuff at your school. The idea of understanding the difference between dating and domestic violence today is very complicated on college campuses. You go try to figure it out. I interview students all the time. You say, "Are you all dating?" They'll say, "Well, we've been talking." "Do you live here?" Right? Because if you're going to be a domestic violence survivor, you have to be a domestic partner, ergo you live together. Do you live here? "Well, I stay here sometimes." Right? You're not going to be able to tell the difference half the time about who's a dating or domestic partner. The department is not interested in dinging you because you put the crime in one category versus the other. Right? The idea is to identify that these things are happening and then take steps to try to stop them from occurring. Right? That's everything that we're trying to do in the Clery Act, even in the Title IX space. One thing that you could do is make sure that your school has a Title IX coordinator. If you're told we don't have one, or we can't afford one, or the last one quit 18 months ago and we never replaced them, that's not acceptable. You have to have a Title IX coordinator. If you have somebody who works in HR or handles some kind of HR process for you, they're probably the most sensible person to give it to because they've already had to educate themselves on many aspects of things like sexual discrimination, right? But don't tell the department you don't have one. And don't just make it up and say, "Well, we just tagged somebody the other day," in addition to the other 10 jobs they have, right? Because they won't be able to answer basic questions about what they're supposed to do. Make sure that you have some kind of a process to conduct a sensible investigation in and around accusations of sexual assault or other intimate partner violence. A lot of small schools are going to outsource this. That's entirely reasonable. Might not make sense for those schools to have any kind of full-time investigator, of course. Or they might simply train somebody who's already on the staff to conduct those investigations, or send them off to training, right, to learn how to do it. We have to make sure we have a fair, prompt, and impartial process. That terminology will sound very similar to people who understand Title IX. There's a familiarity there. They use similar language, right? What are we already seeing if you watch the press in higher ed? We had a big move over the last couple of years to try to address all of the problems in student conduct processes around campus sexual assault. And maybe the pendulum swung a little too much this way, right? And you know what? Now it's swinging back. You're seeing the first set of cases where persons who were accused of sexual impropriety suing and saying, I don't think the school gave me a fair process. Because at some schools, here's what you get. This is what people call an investigation. Some administrator, like a dean, calls the alleged victim in and says, okay, tell me what happened, and tell me the rest, and they write it down, and they call that an investigative report. And somebody takes action on that report. Now the accused person says, wait a minute, none of that happened. Where's my due process, right? Now, we had a lot of schools in this country that hadn't found anybody responsible for a sexual assault in more than a decade. There was a huge problem in this area. I'm simply saying you want to be mindful that to not have it blow back on you, right? Have a fair investigative process. That's going to keep you in good stead with Clery and with Title IX. Now, one of the things that I want to let you know is that the new Clery Act regulations that implemented the VAWA requirements, I mean, they're barely new anymore. They're a couple years old, but we're still kind of gearing up to full implementation in some respects, and certainly many schools are. We did not affect the Title IX requirements at all. Title IX is as it ever was, subject to changes that they've made through their various guidance, right? But we haven't done anything in the Clery area that specifically changes Title IX. That brings up this point, the one in red at the bottom. There are no specific contradictions at the intersect of Clery, Title IX, and FERPA. You will hear people tell you all the time that there are. A contradiction, by definition, would mean that if you complied with some provision of Clery, it would cause you to violate Title IX or vice versa, or that by complying with both, you violate FERPA some way. It simply isn't true, okay? There have been whole sessions at conferences about this very topic, and for the most part, the session just turns into we'll clean it up, a litany of complaints about the Department of Ed and about our rules, but there aren't any real contradictions, okay? Now, this brings us back around to this quote that I started with. It ain't what you don't know that gets you into trouble. It's what you know for sure that just ain't necessarily so. All right? Somebody at your school has to be thinking about these things. Somebody needs to be thinking about what would we do if for no reason at all some person came into our school and started shooting. That's never your fault that happened. That belongs to the criminal. If you read our Penn State report, one of the things that I insisted on having in there is something that is sort of a nod to the students and employees and alumni of that university to remind them that yes, the Department of Education has found the school to be in violation. It doesn't accrue to you. You're not responsible for Jerry Sandusky. He's responsible for his crimes. There may be a group of people at the school who did the wrong thing, but that is not the fault of everyone else. So we need to keep those things in perspective. But somebody at every school needs to be thinking about safety. I think about it when I'm in a facility like this, right? Because I'm into threat assessment. Buildings like this, buildings like schools, casinos, shopping malls, all are designed as labyrinths to keep people in them. Somebody has to think about the fast way out. I think about it every time I'm in one of these kinds of conference facilities. I can't walk in a place like this without thinking about how I would evacuate it, right? Yesterday, when there was the weather event, there were kind of people scurrying all over this place, right? And what sense does that make, right? If you have a school that's in a mall somewhere, we have schools that aren't allowed to have safety drills. Their leases prohibit it. Title IV basically requires it under the Clery Act to do like a fire drill or a safety drill. You got to talk to your landlord about that and work it out. But somebody would have to come up with the idea in the first place, and that's my point. If you want to get some more resources or information about this, I would start with the handbook. You can just Google that. It'll pop right up. You can also call our help desk. The 800 number is there, as is the email address. You can also reach out to me or to the Clery team at our general inquiries email. Because they're not going to throw us out of here right away, I would certainly be willing to take a few questions if anybody has any. Thank you.